Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and estate planning attorney in New York. Today I'll be speaking about estate planning questions and solutions in the context of COVID-19. Before I address those questions, if you need to speak with me, if you would like to speak with me, please go to callfrankbruno.com. There's plenty to be concerned about during the coronavirus public health emergency. But one topic that individuals and families can think of as a practical outlet for their concerns is estate planning. Let's consider a few questions. They are likely to be timely for you and your family, and unfortunately, there really are solutions for all of these estate planning issues, especially in light of the fact that there's more time home together than we normally would have in our busy day-to-day. This is the time for deeply personal conversations to make your estate planning effective and aligned with your values. You can channel whatever anxiety you're experiencing into positive actions that can help you be more prepared for whatever comes next. Beyond the practical benefits, it can be empowering to know that you have an estate plan in place, and such empowerment can be comforting during times of adversity. A couple of questions. How will medical decisions be made if I'm not able to communicate my wishes? Well, we have a solution for that by use of certain documents. A healthcare proxy makes your healthcare wishes known should you become incapacitated. It's a useful tool because it eliminates the added stress upon your loved ones of guessing what you would want during any type of health crisis. You also help your loved ones and even yourself by adding a HIPAA authorization to your estate plan as well. It's a good time to do that. These healthcare documents work together. Your healthcare proxy states your wishes and names the person who can act on your behalf to fulfill those wishes, and your HIPAA authorization is needed to ensure that the healthcare providers can share your private information with the persons named in your proxy or named in the HIPAA authorization. Each of these documents is common, it's brief, and what I mean by common is that healthcare professionals, doctors, are very familiar with them. So if you have them, there'll be fewer roadblocks to receiving the care that you need timely. Another question, what would happen if I can't manage my own finances due to illness? Well, that could be solved by getting a durable power of attorney. That document names a trusted person to concern themselves with your financial matters should you be incapacitated. And the authority of a durable power of attorney can include paying your bills, managing investments, even operating your business. Financial institutions, CPAs, and professionals are familiar with these. Having one in place can prevent issues if you should become temporary incapacitated due to illness or otherwise. And finally today, what would happen to my minor children if I pass away? Well, a will allows you to name a guardian that you would like to take care of your minor children in the event of your untimely death. If you were to die without a will, and to have a guardianship provision in that, each state has its own default rules about guardianship of minors. But that choice really is too meaningful to leave it up to the state laws. Having a will with a guardianship provision in place empowers you to make that decision for yourself. So I answered 3 questions today. Tomorrow I will answer some more questions in considering estate planning considerations during COVID-19 situation, this COVID-19 situation. If you would like to speak with me, please go to callfrankbruno.com. Thank you very much.